Hello, everybody.
This is in the District Court of Butler County, Kansas, case entitled State of Kansas versus Taylor Parite. It's case number 2024 CR 473. James Watts appears as defense counsel. Amber Norris as prosecuting attorney. Taylor Parite appears eventually by his own Zoom. Mr. Parite, we need to clear something up right from the start. You were in court on November the 25th, where this hearing was set. And you were specifically told that you needed to appear at the Judicial Center in El Dorado or at your attorney's office. Now, I'm sure that I was clear and unequivocal about that. One of the reasons why I require that is to avoid the very type of technology.
I had a family emergency.
Just a minute. To avoid the technology issues that you experienced this morning with an inability or fumbling around to try to join us by video and audio. That could have been avoided if you would have appeared at one of the two places that I ordered you to appear. You've decided on your own not to follow the court's order, and quite frankly, Mr. Parite, I don't like it. Do you have an explanation?
I had a family emergency.
A family emergency. You know, it's just amazing to me, Mr. Parite, how many family emergencies pop up when somebody has a court date. Well, I'm very happy with you, Mr. Parite. And I hope we don't struggle with technology the rest of this hearing, because you are supposed to be in your attorney's office. Mr. Watts' technology is very, very reliable, as well as the judicial centers. I can count on it. I can rely upon it. Where are you at right now physically, Mr. Parite?
I'm in Houston, Texas, at
Houston, Texas.
On my way to Indiana.
Do you have a restriction on your bond not to leave the state of Kansas?
Yes, sir.
So you violated that order too, right?
Yes, sir.
All right, what is the business we're to conduct here? This is set for evidentiary preliminary hearing. Mr. Watts?
It was, Your Honor. I've had a chance to speak with Mr. Prees this morning. Ms. Norris had made a proposal yesterday afternoon by email about resolving this matter. It's my understanding Mr. Prees wishes to accept that offer. That would be counts 2 and 3, identity theft and misdemeanor theft, dismissing count 1.
All right, Mr. Parite, implicit in that, and I trust that is what you're intending to do today. Is that correct?
Yes, sir.
We're going to deal with the issue of preliminary hearing so I can let these witnesses go. All right, Mr. Parite, do you understand that a preliminary hearing is a proceeding to determine if there's probable cause that a felony crime has been committed and that you committed it?
Yes, sir.
You understand that if you waive preliminary hearing, the court will bind you over for trial at this point without any further determination of probable cause?
Yes, sir.
You understand that once you waive your right to a preliminary hearing, you cannot get that right back, though you may proceed to trial later?
Yes, sir.
Have you had an opportunity to consult with your lawyer before making a decision to waive?
Yes, sir.
And do you now freely and voluntarily waive your right to a preliminary hearing in this case?
Yes, sir.
Does the state of Kansas waive its right to a preliminary hearing, Ms. Norris?
Yes, Your Honor.
Court finds that both parties have knowingly waived their rights to a preliminary hearing. Defendant is bound over for trial on any and all felony charges of the information. In light of the court's acceptance of that waiver, I can release all witnesses that were subpoenaed to testify this morning. I did greatly appreciate your patience this morning as we got started and for your attendance here today. But I can go ahead and let you leave the meeting at this time.
Thank you, Your Honor.
Thank you.
Thank
you.
Thank you, Your Honor.
Thank you, Your Honor.
Oh.
Did I lose my defendant?
Yes, Your Honor.
I'm going to presuppose he's going to try to get right back on.
Your Honor, just spoke with Mr. Preet. He's signing back on right now. And there he is.
All right. I will note for the record that Mr. Preet has now rejoined this proceeding by Zoom. Mr. Preet,
Yes, sir.
what happened?
The lost connection.
Lost connection. Hope we don't lose connection again, Mr. Preet.
Yes, sir.
All right, it's been announced that you're now going to accept conviction by pleading guilty to 2 of the 3 counts in this case. Count 2 being identity theft, a level 8 non-person felony, and count 3 theft, a class A non-person misdemeanor. Is that what you intend to do?
Yes, sir.
But I've got a whole series of questions I need to ask you regarding the taking of a felony plea. If there's anything asked of you that you do not understand, I will give you the opportunity to confer privately with your lawyer. I would have greatly preferred that you be in his office right now, where it would be much easier for you to confer with him. But since you've elected not to follow the court's order and you're participating very, very remotely, I hope we don't have any technology issues, Mr. Preet. State your full legal name for the record.
Taylor Marbury,
How old are you right now?
28,
What's the highest level of education that you've attained?
high school.
You believe you're going to have difficulty understanding any of the legal concepts we're going to be discussing in court here this morning?
Sir,
Do you think you're going to have difficulty understanding any of the legal matters that we're going to be discussing here
sir.
this morning? All right, let me finish my question before you begin to answer, okay?
Yes, sir.
Have you ever been adjudged to be mentally ill?
No, sir.
Are you currently under the influence of alcohol or any drug?
No, sir.
Are you currently taking any type of prescription medication?
No, sir.
Are you supposed to be taking any mental health meds that you are not currently taking?
No, sir.
So, Mr. Preet, it's my understanding that your mind is clear and that you have a full understanding of what's going on here in court. Is that the case? I didn't hear you.
Yes, sir.
Did you receive a
Yes, sir.
copy of the original charging document in the case, Mr. Preet?
Yes, sir.
Do you understand the nature of the charge in count 2, identity theft?
Yes, sir.
Is your vehicle moving?
Yes, sir. I'm not driving.
Pull over. Find a safe place to pull over.
I'm not driving.
I don't care. Pull over.
All right.
I don't want to get motion sickness watching you on screen. This is a serious matter, Mr. Preet. You don't seem to be taking it seriously at all. All right, Mr. Preet, do you understand the nature of the charge of theft?
Yes, sir.
You understand that when you enter pleas of guilty, you are admitting the acts charged in counts 2 and 3 as alleged by the state.
Yes, sir.
And you also understand that when you enter a plea of guilty, you're giving up any legal defenses that you might have had to those charges.
Yes, sir.
Are you aware that in a trial, the state must present evidence against you in open court, that any witnesses must testify in open court in your presence, that you have the right to cross-examine witnesses with the assistance of your lawyer, Mr. Watts, and that at a trial, you could present evidence on your own behalf and subpoena your own witnesses to court?
Yes, sir.
You also understand that at such a trial, you would have a privilege against self-incrimination, which means that you could get up on the witness stand under oath and tell your side of the story at your choice, but no one could force you or compel you to testify against yourself if you didn't want to. You understand that?
Yes, sir.
You understand that by entering a plea of guilty, you give up these valuable trial rights that the court has described?
Yes, sir.
Are you aware that you have a right to a trial by jury and that before you could be found guilty, that jury would have to be satisfied as to your guilt beyond a reasonable doubt?
Yes, sir.
You understand that when you enter a plea of guilty, you give up your right to a trial by jury and the requirement that you be found guilty beyond a reasonable doubt.
Yes, sir.
You understand that you have a right to appeal a guilty verdict if you have a trial.
Yes, sir.
Do you understand that you may appeal your sentence after entering a plea of guilty, but generally you may not appeal your judgments of conviction after you enter such pleas?
Yes, sir.
Now, are you aware of the sentences that could be imposed as a result of these guilty pleas that you're attempting to make?
Yes, sir.
All right, well, let's go over those. Identity theft is a level 8 felony charge in the state of Kansas, Mr. Paree. On the level 8 line of the non-drug offense grid, in the most favorable criminal history category of I, you can receive as little as a 7-month sentence. However, in the most serious criminal history category of A, you could receive up to a 23-month prison sentence. So the sentencing range is 7 to 23 months in prison, depending on your criminal history. Mr. Paree, as you sit in the car today, we do not know with certainty what your criminal history is. You better than anyone else here ought to know what your own criminal record looks like. But that will be researched by the Court Services Department. And based on the outcome of their research, as of the date of your sentencing, that will determine where you fall along the level 8 line, and then you'll be sentenced accordingly. You understand that?
Yes, sir.
Mr. Paree, though a great deal of that grid line is presumptive probation, if you have 2 or more person felonies on your record at time of sentencing, you will be presumptive prison here. Do you understand that?
Yes, sir.
You also understand that you could receive up to a $100,000 fine for this offense.
Yes, sir.
Count 3 is a Class A non-person misdemeanor. Do you understand that that's punishable by up to a $2,500 fine and up to 1 year in the county jail, or both?
Yes, sir.
You also understand that as a direct consequence of this plea, you could be assessed and be required to pay court costs, certain fees, including reimbursement of legal fees and expenses, and restitution to victims, if any are owed, as part of your sentencing orders.
Yes, sir.
Do you also understand that you will be sentenced to an extended period of reporting probation, reporting parole, or post-release supervision, which is your state parole time that you do after you get out of prison, as deemed appropriate by the court at time of sentencing?
Yes, sir.
You also understand that the Kansas Sentencing Guidelines Act has many special sentencing rules. Do you understand that if any special rules apply to you and your situation, it could affect your eligibility for probation or otherwise affect your sentence? You understand that, Mr. Paree?
Yes, sir.
Did you have an ample opportunity to discuss legal matters like that with your attorney, James Watts, before proceeding here today?
Yes, sir.
You want any more time with him privately now before we go further?
Do I need any more time privately?
Yes.
No,
You need to talk to
sir.
your lawyer before we go on.
No, sir.
Are you satisfied with the services and advice given to you by your attorney?
Yes, sir.
Now, this guilty plea that you're attempting to make, has it been based upon any threat or promises as to what this court will do in regards to your sentencing or any other type of threat or promise?
No, sir.
You understand, Mr. Paree, that if there have been any plea agreements between your counsel and the county attorney's office regarding sentencing recommendations, that this court is not bound by any agreements made. The court may and shall consider them as recommendations, but is not bound by them. Do you understand that?
Yes, sir.
So how do you plead to the charge in count 2, identity theft, a level 8 non-person felony?
Guilty.
And to count 3, theft, a class A non-person misdemeanor?
Guilty.
According to the state's charging document, this all took place October 13 of 2024. Is that when it happened?
Yes, sir.
And it was somewhere in Butler County, Kansas. Where was it?
In El Dorado.
Okay. What did you do that would constitute identity theft, Mr. Preet?
For the per diem card,
What?
the per diem card,
Okay. I can tell you what the charging document says, Mr. Preet. You apparently used Jonathan Medina's name and date of birth. Did you do that?
no, it was a per diem card.
Okay. I'm not sure what you're saying.
It's a card we get at work.
Okay. So you used someone else's card?
Yes,
And
sir.
what did you do with that?
I pull cash off of it.
Okay. And you didn't have permission of this Jonathan Medina to do that. Is that correct?
Correct.
Okay. According to count 3, you took or stole $853 and a wallet and its contents. Is that right?
It was just cash.
Okay. And you used Jonathan Medina's name with the intent to defraud that person or someone else. Is that correct?
No, sir. Never to defraud him.
May I inquire, Your Honor?
Excuse me?
May I inquire, Your Honor?
You may.
Mr. Preet, this was a per diem card for expenses while you're working at turnaround at the refinery. Is that correct?
Correct.
Okay. In order to take money off, that per diem card is assigned to a particular individual. Is that correct?
Correct.
Okay. In order to take money off of that card, in this case, the card belonging to Jonathan Medina, you would have to essentially claim to be Jonathan Medina. Is that correct?
Correct. Correct.
Okay. And in that way, you would basically defraud someone by claiming you are someone that you were not, correct?
Correct. Correct.
Will that assist, Your Honor?
It will. Mr. Medina, do you now freely, knowingly, and voluntarily enter pleas of guilty and accept conviction for the crime charged in count 2, identity theft, a level 8 non-person felony, and count 3, theft, a class A non-person misdemeanor?
Yes, sir.
Mr. Watts, do you know of any legal reason why the court shouldn't accept Mr. Preet's plea?
No, Your Honor.
Ms. Norris, are you aware of any such legal reason?
No, Your Honor.
All right, Mr. Preet, do you know of any legal reason or any other good reason why the court shouldn't accept your pleas here this morning?
No, sir.
Court will accept the guilty pleas made by the defendant and finds that those pleas are made voluntarily. He has an understanding of the nature of his charges and the consequences of his plea. The factual basis for each charge does exist. The court finds the defendant guilty and adjudges him therefore convicted of the crime charged in count 2, identity theft, a level 8 non-person felony, and count 3, theft, a class A non-person misdemeanor. Count 1 is dismissed pursuant to plea agreement. Court orders a pre-sentence report be completed to accurately determine Mr. Preet's criminal history, and the court will set an appropriate date for sentencing. Earlier, Mr. Preet, you talked about El Dorado, Kansas. Do you know where El Dorado, Kansas is?
Yes, sir.
Okay. You seem to have forgotten that today when you were supposed to have been there. But your sentencing will be with you being present in El Dorado, Kansas, and nowhere else. Do you understand that?
Yes, sir.
I'd like to sentence you right now if I could, Mr. Preet, but there needs to be a pre-sentence investigation to research your criminal history and deal with some other matters. That generally takes about 2 months. So I'm going to look for a court date about 2 months out. Counsel, I'm currently looking at Wednesday, March 12th. Mr. Watts, Ms. Norris. I have some flexibility on time on that date, March 12th.
I can do that, Your Honor, about any time the court wishes to do it.
Ms. Norris?
Your Honor, if we could go either later in the morning or at least after maybe 2:30.
All right, would 11 o'clock a.m. work?
Yes, Your Honor.
All right, I will set the sentencing for Taylor Parite Wednesday, March 12th, 11 o'clock a.m. Taylor Parite is ordered by this court to be personally present at the Butler County Judicial Center in El Dorado, Kansas, and no other location. I need you to repeat that back to me, Mr. Parite. Where do you need to be?
Butler County Judicial Center,
And what
11 a.m.
city and state is that?
El Dorado, Kansas.
All right. I'm still very displeased you didn't follow the court's order before, Mr. Parite. We had a late start and complication because you didn't. Quite frankly, I just want to get you to sentencing. You are ordered to fully comply with any pre-sentence assessments that are necessary in this case. I'm going to need you to immediately contact Butler County Court Services Department and follow their direction as to what you need to do to facilitate the pre-sentence investigation. You're going to have to perhaps do some assessments or some testing. I don't know,
Yes.
but you're going to need to follow their direction. Do you have something to write down a phone number, Mr. Parite?
Yes, sir. Hold on.
Okay, I think you're going to need to call the number of area code 316, I think is the
All
correct number.
right.
Did you get that? Mr. Parite?
Yes, sir.
Okay, would you repeat the number back to me, please?
Yes, sir. I got it.
Repeat it back,
316
please.
322.
Correct. If you'll call that immediately after this hearing, you'll talk to someone from the Court Services Department and then follow their direction as to what you need to do regarding this pre-sentence investigation process.
Yes, sir.
Okay? And do that right away. Then I'll need you in El Dorado, Kansas, Butler County Judicial Center for sentencing Wednesday, March 12, 11 o'clock a.m. All right. Mr. Watts, are you aware of anything further we need to address here?
I don't believe so, Your Honor. Thank you.
Ms. Norris, anything further at this time?
No, Your Honor. Thank you.
All right. Mr. Parite, do you have any questions about what we've done here this morning?
No, sir.
All right, Mr. Parite, make that call, then you can get back on the road. There's nothing further then. The Parite matter is in recess. This is in the District Court of Butler County, Kansas, case entitled State of Kansas versus Taylor Parite. It's case number 2024 CR 473. Amber Norris appears on behalf of the state of Kansas. James Watts as defense counsel. Defendant, contrary to the court's earlier order, does not appear at the Judicial Center, but rather is appearing from some remote location. Where are you, Mr. Parite?
I'm currently in a rehab.
Okay, and do you happen to know the city and state of your rehab?
Monroe, Louisiana.
Okay. We'll get into that here in just a moment.
Yes,
The matter
sir.
comes before the court at this time for a scheduled felony sentencing, the court noting, but on January 16, 2025, the defendant appeared remotely, reportedly in Texas at the time. The defendant at that time pled guilty to count 2, identity theft, a level 8 felony, and count 3, theft, a class A misdemeanor. Pre-sentence report was ordered. The defendant was ordered to comply with all assessments. Sentencing was set for today at 11 o'clock. Defendant must appear at the Judicial Center, no other place. Defendant admonished for not following the court's orders and appearing by Zoom. Furthermore, court has received a report from Court Services Officer Christine Donovan. That date to report is March 6, 2025. I'll read it into the record. The defendant is scheduled for sentencing on March 12, 2025 at 11 o'clock a.m. for identity theft, a level 8 non-person felony, and theft, a class A non-person misdemeanor. Attempts were made to contact the defendant by telephone and mail to schedule an LSCMI interview, but he has not responded. The pre-sentence investigation is incomplete as a result. Christine Donovan, Court Services Officer. Do you, other than the emails that you sent yesterday, Ms. Donovan, I'm aware of them and their contents, what is the current status of the pre-sentence report? Have you conducted a criminal history on Mr. Parite?
Your Honor, I have. I, just so the court is aware, I've also had contact with Mr. Paree and his counselor as well. And I have scheduled the LSCMI interview for March 20th at 1 o'clock. So they are going to help facilitate that at the program he is located at currently. And with that being said, I would just ask for some additional time to complete the PSI after that.
All right, based on your research of criminal history, where will Mr. Paree fall into a criminal history category?
Your Honor, I have a lot of out-of-state records for him currently, and I want to follow up on those because it appeared that most of those were pending cases, and I don't want to commit to his criminal history until I just verify that none of them were actual convictions, and they are all in the state of Louisiana.
All right. The court is at least curious regarding how Mr. Paree, who reportedly was in Texas in January, is now in Louisiana, apparently subject to Louisiana court or tribal court orders detaining him, placing him in a rehab facility. How did you get to Louisiana, Mr. Paree? Unmute yourself and explain.
I live in Louisiana.
Were you in Texas in January, like you represented to the court?
Yes, I was visiting my father, who had a doctor's appointment at MD Anderson.
How long do you expect to be in your current facility?
Over here, I'm gonna be here for 90 days.
And when did that start?
Admission was on Taylor. It was on hold on. Admission was on 3/3.
Admission was on 3/3.
You haven't been there very long.
I was in another facility before that.
What is the state's position here, Ms. Norris?
Your Honor, obviously we don't have the PSI, so we can't proceed with sentencing. It sounds like he is under orders from another court. I'll leave it to this court's discretion on how you wish to deal with his bond. But it does sound like we're at least going to be able to get the PSI completed, and they're going to help facilitate the LSCMI or LSIR, whichever form they're using at the moment.
Mr. Watts, as defense counsel, what is your position here?
Your Honor, we'd ask the court to set this matter off until after the PSI is completed. It sounds like his release is in June. So he's unable to be here physically until June, until that release. Whether I see Mr. Preach shaking his head, are you still not going to be able to be here?
Your Honor, this is, and Mr. Watts, this is Ashley Kinman. I'm his social worker, appointed social worker with the Tunica Biloxi Tribe of Marksville, Louisiana. Just to kind of clarify and give you guys a little bit of update on how things function here on the tribal federal grounds and in our parish, which is county. Mr. Paree was arrested with some charges with the local county and got pre-sentenced, and before hearing he was arrested on trial.
Okay, we've lost audio on Ms. Kinman.
Can you hear me?
I can hear her just fine, Judge.
As can I.
Maybe I've just lost audio.
I'm sorry, just let me know when you can hear me.
I can hear you now.
Okay, so following his local arrest, he was arrested on tribal grounds. So myself and our tribal judge worked with our local district attorney, and in lieu of sentencing time, we agreed to put him on a case plan and a restricted detainer into facilities to that would adhere to his mental health and his substance abuse treatment. However, in the state of Louisiana, we do not have local providers that will do a 12-month straight program. So he has gone into a multiple phase program. He has completed his first phase, which was, I think, a 60-day program of intense inpatient lockdown, UA screens, counseling, anger management classes, so forth. He graduated that, and now he's in his second program, which is another program that is subject to be 90 days to continue his treatment, but he does have a little bit more freedom versus a lockdown. He is able to communicate with family, but he is responsible to seek other outside treatment along what he's getting. If he successfully graduates that in 90 days, he will then proceed to the next phase. Our local county and federal judge did a detainer up to 12 months. So he is committed. If he violates that, then he will be sentenced and incarcerated in the state of Louisiana. I hope that helps. If you have any questions, I know we do things a little bit differently here. One of the advantages of having him being a tribal citizen is we have the funding and the capability to assist him in his addictions and his poor choices that he's made. Now he has to suffer consequences, but unfortunately our local jails are not beneficial. So we're giving him the benefit of the doubt, and we're at our last straw here. He has been cooperative. He has been compliant. He's passing these drug screens, but he will, even after these 12 months, our federal judge will do a continuation of a treatment plan that may be modified, but he will continue to be followed by our services up to 2 years.
Very well. Thank you for your statement to this court, Ms. Kinman.
Yes, sir. Thank you.
All right. Ms. Donovan, based on the current schedule with the LSCMI on March the 20th, what would your reasonable projection be as to when that report will be ready for purposes of rescheduling this sentencing proceeding?
Your Honor, I would ask for at least 3 weeks from today.
Certainly seems like a reasonable request. Looks like Mr. Parit's scheduled to be right where he is right now. When we reschedule this case, I'm going to address my assistant for a moment. Mandy, do I have 1:15 on Wednesday, April 2?
Yes, Judge.
I will propose that date and time, 1:15 p.m. Wednesday, April the 2nd, Counsel. Mr. Watts, if you're talking, I can't hear you.
Yes, sir, I can do that.
Okay. Hearing no objection from the state. Excuse
Your
me?
Honor, you still are allowing him to do this via Zoom and not in person.
Yes.
Okay, thank you.
Yes. I think requiring him to appear here would probably disrupt more and cause more problems than what it would solve. I do appreciate your involvement here. It does appear that Mr. Parit's part of a monitored long-term program,
Yes, sir.
generally centered around making him better,
Yes, sir.
and the court doesn't want to interfere with that currently.
Thank you. I appreciate that. It really means a lot to myself and Mr. Parit.
Also, the court obviously is putting a great deal of weight in the fact that documentation has been provided to this court that he's currently under a detainer from a federal judge.
Yes, sir.
So that assures the court that this isn't something voluntary that Mr. Parit's doing to avoid responsibilities here in Kansas, but rather he just simply submitting to the authority of the state of Louisiana and getting help in the process.
Yes, sir.
So 1:15 Wednesday, April 2 by Zoom. Mandy, for simplicity purposes, can we use the same Zoom numbers that we did today?
They won't be available, Judge.
Okay. Oh, I'm glad I asked then. You'll all receive a new Zoom invitation. Do you have Ms. Kinman's email address, Mandy?
No, but I think Christine does. Okay.
I do, Your Honor.
All right, Christine, would you provide that to Mandy so she can
Yes,
make
I
sure
will.
that Ms. Kinman is able to coordinate Zoom for Mr. Parit?
Yes.
All right. Mr. Watts, as defense counsel, are you aware of anything else that we need to address today?
Not at this time, Your Honor. Thank you.
Ms. Norris, as prosecuting attorney, anything further at this time?
No, Your Honor, thank you.
Mr. Preet, do you have any questions about what we've done here?
No, Your Honor. Thank you
All right.
very much.
All right. Make sure that you're on the Zoom meeting at 1:15, Wednesday, April 2nd. Make sure you comply with the rules of the facility that you're in.
Yes, sir. Thank you, Your Honor.
And furthermore, last but not least, I'm going to expect that you fully comply with any pre-sentence assessments which are still necessary, including this risk needs assessment that you're going to be doing on March the 20th at 1. Okay?
Yes, sir, Your Honor.
All right. We'll see you Wednesday, April 2nd, 1:15 p.m. by Zoom. If there's nothing further, the Preet matter is currently in recess. This meeting may be ended for all.
Be safe, be well, sleep sweet, and much love.